Have you ever wondered, when speaking to a friend or colleague over the phone, whether the information being passed across can be accessed by a third party? Good day, esteemed viewers. My name is Yewande Adesope, a 300-level student of the University of Ibadan and an undergraduate intern at HARLEM Solicitors. And today, I'll be taking you on a brief but insightful journey on the lawful interception of communications in Nigeria. By the end of this lecture, you should know what lawful interception is and what constitutes unlawful interception, who can carry out this interception, and the legal justification and framework for the lawful interception of communications in Nigeria. Before I go on with the lecture, I'm going to define a few terms for easier understanding of the lecture, as these terms will be reoccurring. 1. Communication. Communication refers to the information being passed across from one party to another party through the use of electronic transmissions, such as phones or computers, and such information could be in the form of voice notes, text messages, or phone calls. Then, lawful interception. Lawful interception is a legally authorized security process carried out by a service provider or a class of service providers to collect, retain, or monitor the information of private individuals and organizations. Of course, the first question to consider with the lawful interception of communications is an individual's right to privacy. Every person is entitled to keep their personal affairs to themselves, and this is provided for in the ground norm, the Constitution of the Federal Republic of Nigeria, 1999, as amended, hereinafter referred to as the 1999 Constitution, which states in Section 37 that the privacy of citizens, their homes, their correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. From this, we can see that everyone is entitled to the right to privacy. However, to every law, rule, or right, there's usually an exception or a limitation, and this limitation is provided for in Section 45 of the 1999 Constitution, which states that nothing in Section 37, being the right to privacy, shall invalidate any law that is reasonably justifiable in a democratic society in the interest of defense, public safety, public order, public morality, or public health. So when there is any law that limits the right to privacy, however, that law is not reasonably justifiable in a democratic society, meaning that it is not in the interest of the people or for the public, then such law will be said to not have fulfilled the constitutional conditions to limit the right to privacy, and that law will be declared as null and void. There are many laws that govern the lawful interception of communications in Nigeria. However, in this video lecture, I'm going to be taking 4 laws. 1. The Nigerian Communications Act 2003, the Lawful Interception of Communications Regulations 2019, the Cybercrimes Prohibition Prevention Act 2015, and the Terrorism Prevention Act 2011. The Nigerian Communications Act 2003, hereinafter referred to as the NCA 2003, is the principal legislation governing telecommunications, the provision of internet services, and information and communication technology in Nigeria. From this small definition, we can see that the NCA 2003 actually has jurisdiction over the lawful interception of communications in Nigeria. The NCA 2003 defines interception as the oral or other acquisition of the contents of any communications data through the use of electronic or mechanical means, or through any other equipment, device, or apparatus. Section 147 of the NCA 2003 also provides that the NCC, the Nigerian Communications Commission, can permit any service provider to carry on with the interception of communications of private individuals or organizations, and that determination or permission can specify the technical requirements needed for such interception. Section 148 of the NCA 2003 also permits the NCC to enable a service provider to carry on with interception during a public emergency or in the interest of public safety. Section 148, subsection 1, paragraph C, also states that the NCC may determine that any communication to or from any licensee, person, or general public shall not be communicated, or that such communication should be intercepted, or that such intercepted communication be disclosed to an authorized law enforcement agency. The next law to consider is the Lawful Interception of Communications Regulations 2019, hereinafter referred to as the 2019 Regulations. The 2019 Regulations provides that interception can be carried out in 2 different ways: 1, with a warrant, and secondly, without a warrant. As provided in Regulations 8, interception can be carried out without a warrant in 2 circumstances: One, where a party to the communication has given consent to such interception and has sufficient reason to believe that there is a threat to human life. Secondly, where such interception or monitoring is needed in the ordinary course of business. For interception to be carried out with a warrant as provided in Regulation 7 of the 2019 regulations, it's under 5 circumstances. One, in the interest of national security. Secondly, during the investigation of a crime. Thirdly, to protect the economic well-being of the Nigerian citizens. Fourthly, during a public emergency for the interest of public safety. And lastly, to give effect to any international mutual assistance agreements to which Nigeria is a party to. And such application must be made to a judge of the Federal High Court in writing. Regulation 6 also provides that where any information has been intercepted and detained during the investigation of a crime, upon completion of that investigation, that information must be destroyed and any copies made of it must also be destroyed. Regulation 16 further provides the consequences of non-compliance with the provisions of these regulations. The next act to consider is the Cybercrimes Prohibition Prevention Act 2015, hereinafter referred to as the Cybercrimes Act. And the Cybercrimes Act criminalizes unauthorized interception of communications by provision of Section 12 of the Act, which states that unauthorized interception of communications is a crime and such offender is liable on conviction to a term of no more than 2 years imprisonment and a fine of no more than 5 billion naira, or to both such fine and imprisonment. Then the Act also provides for the definition of interception, being the listening or recording to the content of any computer data. And Section 39 of the Cybercrimes Act also provides that interception can be carried out in 2 circumstances. One, during a criminal investigation, or secondly, during a criminal proceeding. And such interception must be ordered by a judge of the Federal High Court. And the judge can order that a service provider assist a law enforcement agency with the collection or recording of such data through the application of technical means, or authorize a law enforcement agency itself with the collection and or recording of such data through the application of technical means. And where a service provider of his own volition decides to carry out interception of communications without approval from a judge, such service provider is liable to a fine of 10 million naira. Section 38 of the Cybercrimes Act provides that all service providers must keep their subscribers' information for a period of 2 years, and that information must not be utilized for any reason except as ordered by the Cybercrimes Act 2015 or as ordered by a court of competent jurisdiction. The Cybercrimes Act further provides the consequences of non-compliance with the provisions of this Act. The final act to be considered in this video lecture is the Terrorism Prevention Act 2011. As we all know, terrorism is very rampant in Nigeria and is usually premeditated through the use of electronic transmissions such as phones or computers. And to prevent such terrorism, the Terrorism Prevention Act 2011 had been established. However, in 2013, there was an amendment made to the Act to form the Terrorism Prevention Amendments Act 2013. Section 29 of this Act provides that interception must be carried out with approval from a judge, and it can be done by a law enforcement agency. And such law enforcement agency must get approval from the Attorney General of the Federation, and the Attorney General of the Federation must in turn get approval from the Coordinator on National Security. The Terrorism Prevention Act also provides that where interception is to be carried out, then such service provider must provide the number of years that such information will be detained for. In conclusion, with all what I've said so far, judicial authorization is needed for the interception of communications in Nigeria, and this is just to balance the right to privacy alongside the interest of the general public. And of course, everyone is entitled to the right to privacy. However, some people use this right to privacy as an umbrella to commit unlawful acts or crimes, and a measure has been created or established to counter these unlawful acts, and that is the lawful interception of communications. For more information, please visit www.harlemsolicitors.com or visit the NCC website. Thank you.